For admission, item number 1.
Please, my lord, in the last court date, I was absent, and my learned friend on my behalf has prayed the matter to be listed after vacation, and I was directed to file the affidavit by yesterday, and the matter be listed today. My lord, even though I have physically joined yesterday, I have made an endeavor to file the affidavit yesterday, but then it can be ready by this morning only, and as we speak, the affidavit is being filed, my lord. And I have served the copy to the respondent, my
You
lord.
will have it immediately after the vacation.
Yes, my lord.
You are also appearing online for the petitioner.
Yes, Your Lordship.
Okay, we'll have it after the vacation.
Yes, Your Lordship.
Ms. Swinson Leonard, Government Advocate, State of Mizoram, who has appeared online, has submitted that the affidavit has been filed, is being filed today, and a copy thereof has already been served on the learned counsel for the petitioner. Para, in view of the above, let the matter be listed immediately after the winter vacation, and the affidavit said to be filed be tagged with the court records.
Much obliged, Your Lordship.
Be obliged.
For orders, item number 2.
May it please your lordships.
Yes.
My lord, the instant WA has been filed challenging the order passed by the learned single judge of this honorable court on 16/11/2023. Now, my lord, the case is that when the instant respondent number 1 herein had filed WPC number 104 of 2023, asking for payment of land value for his land. And when the matter was taken up on 16/11/2023, the appellant herein had not yet filed the affidavit. And so the matter was taken up anyway.
So we are on the aspect of delay condonation.
Yes, my lord.
It has
And
nothing to do with delay condonation. What is the explanation for the delay?
my lord, there is a delay of
359 days.
359 days. And my lord, the instant writ appellant had also previously filed a writ appeal number 13 of 2024 prior to filing of the instant writ appeal. However, due to technical error, the same was withdrawn and liberty was given. Now, my lord, the reason for delay is mainly due to communication delays. And that, my lord,
Communication between whom?
communication between the office of the instant appellant's hearing.
Will that help you?
My lord,
Will that help you? The current trend of the decisions say that you have to be treated at par. You will not get any further benefit or liberty being a government or a government agency.
yes, my lord, that,
From table to table, that aspect has gone.
my lord,
One vetting, one approval, then from this office, that office, those are gone.
my lord, that is,
359 delay, qua an appeal, filed intra-court appeal, where limitation is 30 days,
yes,
is more than 10 times.
my lord,
353 days.
that is there, my lord. However, my lord, the land in question, that prior to the passing of the impugned order, the appellant's hearing had already communicated to the Kala Serchip that the land is no longer required as the proposed road has already been constructed.
That is the submission on the merits of the appeal.
Yes, my
Not
lord.
on the merits.
My lord,
359 days for a writ appeal is inordinate and the gross delay.
my lord, my
Had it been a
grounds,
first appeal where 90 days, then also for 30 days, in intra-court appeal from this court, in the
My
same
lord.
court you are filing an appeal. Why the delay?
my lord, my grounds are from page number 7 of my IA.
We do not know how far we'll be successful. Okay, we'll issue notice. Heard 3 issuance of learned counsel
Yes, my lord.
for the applicant.
My lord, however, since the case was duly proceeded,
We are issuing notice at this stage.
yes, my lord.
Learned counsel for the applicant, who by means of this application filed under section 5 of the limitation at 1963, has prayed for delay of 353 days or 9 days.
369 days, my lord. 59 days.
59 days in preferring the appeal against the judgment dated so and so passed in so and so. Para, let notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respond numbers 1 by registered post with AD.
And accept notice on behalf of the state respondents 2,
State
3, and 4.
Council accepts notice on behalf of respond number 2, 3, and 4. What about 5?
5 is Lordship,
This is
we are
Kala.
not presenting, yes, Kala. They have a different
Let him
council.
write in the, right in. Ms. So-and-so, London State Council accepts notice on behalf of respond number 2, 3, and 4, extra copies. Then you write steps for service of notice upon the respond number 1 and 5 be taken by registered post with AD. Steps within 2 days.
My lord.
List after 6 weeks for service report as well as for objection if so advised.
Deeply
Be
obliged.
obliged.
I seek your lordship's indulgence in making a mention regarding item number 16 of part 2.
16, part
Yes,
2.
my lord, part 2.
Any item left in part 2? 16, 19. 16 is not there, madam.
My lord,
Perhaps
I
a
was
mistake.
informed by the petitioner, counsel for the petitioner, my lord.
Okay, there's an order to be taken after the vacation,
Yes, my lord.
item number 16. Okay. It's already, that was done a long time back, first day of the week. Okay.
Acknowledge.
For motion, item number 1.
Yes,
May I
where-
please, Lordship?
Where's the affidavit?
My lord, I failed to obtain the signature of the deponent, Lordship. Lordship,
Yes. You're not
Lordship,
audible. Yes, yes. You're audible now. Yes, please submit.
yes. Lordship, I failed to obtain the signature of the deponent, Lordship.
When can you
So
file?
I beg for adjournment, Lordship, for
When
today.
can you file? How soon can you file the affidavit? How soon can you
My
file
lord-
the affidavit?
As soon as the vacation is over, Lordship.
You have to tell us. It cannot be an indefinite period. When can you file the affidavit? 1 week, 2 week, when?
1 week, Lordship, after 1 week, Lordship.
Okay.
After 1 week, Lordship.
The learned counsel.
After
for the-
1 week, Lordship.
The learned counsel for the petitioner.
After 1 week, Lordship.
Okay. Who appears online, has prayed for, and is granted further time of a week to file the additional affidavit to explain the delay, which was directed by the last order para list after the vacation to enable filing of such additional affidavit.
Humbly obliged, Lordship.
Item number 2.
Your Lordship, this matter pertains to
There's a
shortening.
caveat, there's a caveat.
Caveat is there,
We discharge the caveat first.
Lordship.
Who is appearing? Mr. AG, you are appearing?
I am for the statement.
Okay. First, Mr. Learned AG, who appears for the caveat, full stop, caveat which has been lodged in connection with so-and-so. The caveat would be heard in the event this court proposes to pass any interim order. Caveat is discharged. Yes.
Lordship, in the caveat application, a notification dated 21 November 2024 has been enclosed. The order which you have challenged is 20 November 2024. Now that notification has been superseded by this 21 November notification. So in view of that, I seek the indulgence of the Honorable Court for allowing me to withdraw this writ petition and to file another writ petition challenging the validity or other ways of this notification dated 21
What is
November.
the difference between these two notifications?
The only difference is that in the earlier notification, the compliance of, there was no compliance of 166, Article 166 of the Constitution of India. The name of the governor was not shown. Here in 21st November, Governor of Mizoram is pleased.
Okay.
The pleasure of governor.
Okay, well, heard three, so-and-so the learned senior counsel for the petitioners. Also heard the learned advocate general Mizoram. Para? Three.
My lord, this needs to be dismissed.
Yes,
because-
dismissal.
Maybe withdraw.
His withdrawal, dismissal on withdrawal.
Dismissed on withdrawal.
The learned senior counsel for the petitioners has pointed out that though the order which was impugned in the writ petition was an order dated 20/11/2024 from the caveat which has been discharged today, it appears that the said notification was superseded by another notification dated 21/11/2024. Full stop. He submits that the latest notification would perhaps be required to be challenged. Full stop.
Right.
He accordingly prays for withdrawal of the writ petition. Full stop. The aforesaid prayer is not opposed by the learned AG. Full stop. Para? Writ petition is accordingly dismissed on withdrawal with liberty to make a fresh challenge if so advised.
Oh, please.
I'm obliged.
For admission, item number 3.
wrongly listed there? Why not? You've noted that? 2 weeks, 2 weeks. In 11, 12, they have not even referred to this order 212, they have referred to 1411. This will come after the vacation. It's wrongly listed.
Yes, my lord, if lordship permits.
Uh, This matter appears to be wrongly listed by the office without taking into consideration the earlier order dated 2/12/2024 para. List accordingly after the vacation in terms of the order dated 2/12/2024.
Obliged.
Item number 4.
May it please your worship. This is a statutory first appeal.
Yes, we'll admit this.
Yes, your
Third three, since the learned counsel for the appellants who by means of this appeal has put to challenge a judgment dated 12/9/2024 passed in so and so. Para, admit. Para, call for the records. Para, let steps be taken for service of notice upon the sole respondent by usual process as well as by registered post with AD. Steps within 2 days.
I'm
Item number 5.
Your Lordship, I have instructions to appear for private respondents in this matter. Respondent 9 to 58. I'll be filing my power by tomorrow, my lord.
9 to 58.
9 to 58.
And state respondent, have you filed the affidavit?
State media.
going. That's all.
State respondents file affidavit? No.
No, Your Lordship, if I may be given some time, Lordship.
Okay. Pursuant to learned counsel has submitted that he has instructions to appear. Instructions to appear on behalf of the respondent numbers 9 to
58, ma'am.
9 to 58, and submits that he will be filing the formal power shortly. Full stop. Both Ms. Swinsul and the State Council, on the other hand, has placed before this court a communication dated 9 December 2024 pertaining to the present case. Para, both the State Council and the Learned Council appearing for the private respondents pray for and are granted 4 weeks time to file affidavit in opposition. List after 4 weeks.
Much obliged, ma'am.
I'm right.
The communication dated 9/12/2024 is made part of, is kept with the records.
For orders, item number 6.
My lord, for respondent number 6. Yes, my lord. I have to file my objection, my lord. However, if I may be given some more time. Yes, my lord.
Part 5.
Yes, my lord. Obliged.
Item number 7.
My lord, in this matter, the counsel for the appellant informed me that he is indisposed. So if the matter may be listed after occasion. Yes. Yes, my lord. Yes. Yes, yes. It's a blessing. Yes, my lord.
Item number 8.
My lord, this is the bail application which was fixed for disposal today, and a scanned copy of the lower case record has been called for, and if we can proceed, Your Lordship. NDPS matter, Your Lordship. Yes, if you please, Your Lordship. On 22nd 10 2022. So as on present date, my lord, the applicant has been in jail for 782 days, or 2 years, 1 month, 20 days as on date. My lord, the applicant was arrested along with 4 other accused, and they have all been charged under Section 22C of the NDPS Act, and no other charge has been made under the NDPS Act, only 22C, Your Lordship. The seizure of the suspected contraband, it was seized in a Tata Sumo Maxi Cab. Tata Sumo Maxi Cab, and it is it is a methamphetamine. It's a tablet of methamphetamine. Merits of the case. Oh, merits of the case. There are 7 witnesses, and it is proceeding very slowly. 3 has been examined, Your Lordship. For the last more than 2 years, only 3 has been examined.
Lordship, she's appearing through VC, the counsel.
My lord, I was on legs. Sorry, my lord. My lord, you're not audible, my lord.
Getting us,
My lord, you're audible now, yes.
okay. What steps are you taking for expeditious completion of the trial? Why only 3 witnesses for all these years?
Yes, my lord, because when notice is served, then it is, the matter is adjourned from time to time because the witnesses are not available on that given day.
Now, why witnesses? What steps are you taking to get the witnesses?
By serving a summon, my lord.
You should ensure their presence. The accused should not be prejudiced. Everyone
Yes.
is entitled to a fair treatment. Whether he's guilty or not, that's a different matter. But in the trial, during the trial, he should be treated fairly. Every
Yes,
day's
ma'am.
incarceration is without trial is not, it's not warranted. And 782 days in custody is a substantial period. You have not processed. Out of 7, you have only examined 3 witnesses. Arrest was
witnesses,
in the year 2022 October. Yes,
Correct.
yes.
Yes, my lord, and the main accused in this case, 2 of them has been released on bail by the NDMPS court. But my bail was rejected.
No, there may be, see, bail depends on the facts and circumstances against each of the 2 have been, the question of parity will come in very exceptional case when same circumstance, and it's a matter of bail, not even the matter of a final judgment.
My lord, my lord. My lord, if I may proceed with the facts of how this arrest was made and why I was prejudiced, it will be apparent, your lordship. My lord, on the date of the, my lord, I am a dry fish seller from a village, dry fish. So I sell dry fish to make a living with my wife, and I'm a permanent resident of Tamparengpui village, which is approximately 1.5 hours from Aizawl. So on every Sunday, for earning my livelihood, me and my wife, sometimes I alone, comes to Aizawl in the market, on the Saturday market, and we sell dry fish. Then we go back home in the evening. And on this particular day, on 22/10/2022, like other Saturdays, me and my wife, we have come to Aizawl to sell our dry fish in the morning. And while we are selling dry fish around 12 o'clock noon, the accused number 1, his name is Sri Larinzwala. He is residing here in Aizawl.
Which was the date? 22/10.
22/10 on a Saturday. While we are selling fish
The
at the
market is on a Saturday or Sunday.
Saturday only. Market, Sunday is closed. So this accused number 1, Larinzwala, who is residing in Aizawl, and he is the cousin brother of my wife. He has come to meet. He has met us in the market while we were selling the fish. And Larinzwala, accused number 1, requested me to accompany him to Sakor Tuichun area. It's a 30 minutes drive from the market. He says that his motorcycle had a problem because of the mechanical problem. It needs to be pushed, so that he needs a passenger to help him on the way. So, and he also says that we'll be back within 1 hour. And the accused number 1 did not tell me anything what he's going to do, just that help him on the way, so that if the vehicle break down, I could help him. So we went. And when we reached the place, the accused number 3 and 5 was already there. They were talking to 2 strangers. And it turns out that the 2 strangers were decoy customers from the anti-narcotics squads. That was later known. So when we reached the place, accused number 1 went to the party, and since I did not know them, he told me to wait for him near the bike. So the accused number 1 went. So
You had gone on a bike.
yeah, I was a pillion rider with the accused number 1. So when we reached, the accused number 1 went to the party. I stayed back waiting for accused number 1 to go back to the market. Then after some time, the sumo came. Because I took out my mobile phone, talked to my wife. I was standing like 20 meters away from the pair because I don't know anyone. I just went there accompanying the accused number 1. And after some time, the sumo came, and out of the bushes, the narcotics squad led by the sub-inspector came out. They put handcuff on the accused number 2, the accused number 1, 3, 5, and the driver of the sumo. And the sumo was searched, and inside they found some methamphetamine. Now the SI arrested all of them, and since I was standing nearby, the SI called me, tell me to come closer. I went, and she asked me what I was doing there. I said, I came with this fellow, accused number 1. Then I was put in handcuffs too. That is my case, and just because I was present there, the SI, there is no other evidence on the court linking me to the.
But is it believable that the vehicle was not a problem? He knew that he was going for some dealings with contraband. Why would he ask you to accompany him on a bike? And why would you accompany him? After going there, you will definitely ask, where is the vehicle which has broken down?
My lord,
And what is the logic?
My
There
lord,
was no vehicle broken down.
no,
Had it been a case that you found a vehicle broken down, then in the meantime this also happened, then why would he take you?
my lord, he has come to the market, accused number one, saying that he has a motorcycle to go there. Motorcycle. He said, my motorcycle is very old, it's broken down, it needs to be pushed to start because the switch is not working. So he cannot sometimes he got failure on the road, so he need assistance. So I was there only for assistance.
Not a believable story.
So, my lord, that will come up from the evidence of the SI herself. If I take your lordship to the,
Believable story for the, at least for the purpose of granting or not granting bail, not a acceptable story. How you prove it in the court, trial court, that's a different matter.
yes, my lord.
Who are the witnesses? See, your chance of 313 has not yet come.
Yes, sir.
If 313, what explanation you try to give, you may also choose to adduce defensive evidence, that's a different matter. But to prima facie make out a case for bail, see, you have 37 in the NDPS,
My lord.
which is over and above the restrictions in the CRPC.
My lord, three
The-
witnesses has been examined.
Presumption, number one.
Yes.
And the presumption is the reverse one, that the prosecution has to come to, court has to come to a conclusion that you did not, if you are released on bail, you are not likely to. This is something very speculative, but still then it's part of the statute book.
My lord. Correct, my lord.
How do you know that after release of bail whether you're going to indulge yourself in this kind of activity? But still then, it's a part of the statute.
Yes,
Court
my
has
lord.
to come to a conclusion that after, if you're released on bail, you are not will not be indulging in similar activities.
On that question, my lord, since I have no prior arrest or anything, no criminal record against me, not even for stealing or anything, let alone NDPS Act. This is the first time I've been arrested, and that is why I am not a peddler of drugs. I am a dry fish seller, and this is purely a case where that I was there at the wrong place at the wrong time, and I was taken into custody for being there only, my lord. And I have some citations from the Supreme Court also, similar matters where this conviction has been overturned. I will come to that later,
See,
my lord.
conviction is a different matter.
And my lord,
Conviction is depending on proof. Now here we are considering bail application.
yes, my lord, the witness number
And
one.
bail application pending trial.
Yes. My lord, the witness number one confirmed my story to some extent. She is the main arresting officer, your lordship. And she has stated that, she has mentioned in
Madam,
the,
have you gone through the case records?
No, my lord.
Why are you online today? We could have given you a copy of this, at least for a glance. See, you need to assist the court by going through these copies. That is what we do regularly in the principal sit. Give a day's time and have it tomorrow. You could have done it. And this 782 days is a substantially long period. What are your submission otherwise?
My lord, my submission is that the trial is ongoing, and then the hurdles of Section 37 is not overcome by the appellant, and it is not a case of the appellant that even though they have stated in ground number 6 that nearly 2 years on date have been they have undergone imprisonment. But then, my lord, they have just mentioned that if acquitted, charges made against him for conclusion trial, it would not be possible to undo his imprisonment. So, my lord, even though he is...
That is not an acceptable proposition. As an under trial, that it's been settled. It's not a question of, but a long incarceration, should be avoided, 782 days. The trial should be completed as soon as possible. But on 37, okay. What otherwise he's trying to make out a case that even the witness number one did support his case. Have you gone through the deposition of witness number one?
Yes, my lord. I have gone through the deposition, but there is in the cross-examination, which is in page number, they have annexed it, my lord, in their petition also. In the cross-examination, she have stated that the accused number 1 have contacted a person, his associate, and it was found that the other accused, Gelabla Shwaizela, was the one he contacted. That's it. Nothing was mentioned about the present applicant, my lord.
Okay,
Just because
where
the
is it?
seizing officer goes silent about
Which page, madam? Which page?
it's
Page 27,
Annexure 6.
Page 27.
Page 27 is the cross-examination.
Yes.
But, my lord, the applicant is Kinon Joy, he's accused number 2. So nothing adverse has been mentioned by the arresting officer regarding me, my lord. So Premen Joy and Robbie Rai, these are accused number 3 and 5. Gelot is accused number 4. Then accused number 1 is Narin Zola. Nothing has been mentioned about accused number 2, me, my lord.
Just a minute.
And my lord, if the witness, PW witness number 3 and 4 also.
Just
also
a minute.
confirmed.
Page 26. What is your name? Kiranjoy?
Kinon Joy, Kinon Joy. K, Kinon Joy. And if your lordship will see, page 28 and
Just a minute.
page
Just a minute. One lakh 50,000. My God. 14 kilo. This is neither here nor there, except from the part of long period of custody.
My lord,
What else do you have?
PW number 3 at page 28 in his cross-examination. This is the witness for arresting witness 3 and 4, your lordship. Your lordship will kindly see the cross-examination.
Yes.
As far as I remember, there were 5 persons at the time of arrest.
However, I cannot exactly identify the accused.
At the place of occurrence.
Okay.
I cannot say who is driving the sumo, and also do not know who is the owner of the said sumo. It is a fact that nothing was recovered from the physical possession of the accused Kinon Joy. It is a fact that I do not know whether mobile or phone call data was seized by the seizing officer. It is fact that I do not have any knowledge in connection with the seizure of the essay prior to the arrest of. He is the main seizure witness, and he says he does not have any knowledge in connection with the seizure at paragraph number 5. The main seizure witness also doesn't know anything. It is a fact that I was informed by the excise person to act as a witness. As far as I remember, it was afternoon when I received the call. The witness was called after the seizure and arrest. He should be there when the seizure was done, but he was called after. It is not a fact that I do not remember the exact quantity of essay. It is a fact that I was not present when the inventory was done. This is the main witness. He does not know anything, the main witness in lordship.
It is a fact that has not been done.
And again, my lord, in the PW number 4 also does not know anything. The two main witnesses in the case.
Who are the rest, 3 witnesses? Rest 4 witnesses?
Rest 4 witnesses are for the judicial magistrate, the assistant director of FSL, and the case IO. That's all. So how will they go?
No, there, you said 7 witnesses, 3 have
One
been-
is dropped. One is dropped. Witness number 2 has been dropped by the prosecution itself.
Judicial magistrate before whom 70 sampling was done,
Yes, sampling was done.
52A.
Yes. And another is the FSL, the report that whether to.
Madam, these are official witnesses. Why won't they come to judicial magistrate? You can also record his submission through VC. It is permissible. Forensic can come. Why don't you expedite? See, with this amount of chemical drugs, we are not too much inclined to grant bail, but we have to balance everything.
Yes, my lord.
In the name of trial, he is in custody for 782 days, pretty long time.
My lord, these 3 witnesses are the only independent witnesses. And how are they going to, based on this evidence, how are they going to convict me, my lord? Because even the witness here, the seizing and arresting witness says he was called later after everything was seized.
The seizure is done by whom?
That will be PW number 2 and 3. And my lord, PW number 3 is the interested witness. He's a constable in the department itself. He should be a civilian. If you see witness number 4, page 30, yellow sheet, only 2 witnesses in the case, and one is the.
No, seizure was done by PW2.
No, my lord. There were 3 seizure witnesses, and
no.
2 of them were.
Who had
from
done
the
the,
narcotics.
who had done the seizure?
It's in the record itself, Your Lordship.
Witness number 1.
Witness number 1 is the seizing officer.
Yes.
Witness number 2, 3, and 4 are the witnesses to the seizure and arrest. And out of them, Your Lordship, out of the 3 witnesses, 2 were from the department itself. From the department itself, anti-narcotics department itself. Only one, PW number 3, is only the civilian witness. And on the only civilian witness says that he doesn't know. So how is the conviction going to be upheld? So the only independent witness here is PW number PW number 2, no, PW number 3, who is a civilian, and that itself cannot be his evidence. And he himself says that he cannot identify Kinon Joy. Only PW number 3, Your Lordship. Others, all the evidence are, they are from the department itself.
But there is some confusion here. In the sheets pertaining to the deposition,
My Lord.
first is witness number 1. Okay?
Yes, my Lord.
He is the
Arresting officer, the main arresting officer.
arresting one. Then we have got
2 was dropped.
2 was dropped.
2 was dropped by the prosecution, and that 2 also, so we cannot take anything to count. Now we come to PW number 3.
3, yes. 3.
PW number 3.
Thereafter another constable is there, PW4.
Yes, my Lord. PW more for evidence cannot be taken because he is himself anti-narcotic squad. He was the member of the raiding party himself.
Why his evidence should not be taken into consideration?
My Lord, under the.
Can you straight away say that his evidence should not be? We have to check his evidence, what he has said. But you cannot say that he cannot be a competent witness.
My Lord, CRPC 41B says that at the time of arrest, the witnesses should be independent civilian witness.
There is one, a PW2.
Yes, my Lord.
PW3 rather.
PW3. So PW number 4 even says that, my lord, if we take PW number 4, supposing, but not, we are not admitting that he's independent witness. We are saying that he's from the department itself. He was from the raiding party itself. But if we take his cross-examination too, your lordship will know that it is a fact that I do not know how many persons were at the
You're
pier.
accompanying the other accused, your story that the vehicle, motorcycle was having some defect. Those are matters which needs to be really seen. Difficult. How did you come in the place of occurrence? You have admitted that you had come, maybe at somebody's instance. But
Yes.
why would he involve you? He's your relative. He is the cousin of your wife.
My lord,
If you are not at all connected with the offense, why would he unnecessarily drag you? You come with me, and if you are caught, you are also caught. Unless you have a complicity.
my lord, that is out of my comprehension. And, my lord, they should have also charged me under section 29. Abatement of conspiracy.
No, it's not a
charge
question.
was made,
It's not
my
a
lord.
question of abatement. It's not a question of
You have the
conspiracy.
common intention on that, but because
We don't know, your active participation may be there. Why should you be along with him?
on the
You were
request
in
of
the, you say that you were a dry fish seller, comes to Aizawl on every Saturday. He is the cousin of your wife, and he is one of the main accused, according to you. Difficult.
my lord,
What decisions are you trying to
yes,
take?
my lord. Supreme 2010 SCC 2257.
2000?
2000
Yes.
volume 10 SCC 257 Ismail Khan Ayub Khan Pathan versus State of Gujarat. My lord, here it says that conviction cannot be held, cannot be sustained only on the basis of the presence of the accused in the room where the narcotics was.
This is not a conviction.
My lord,
You are not convicted. They have to prove the prosecution is still under a heavy burden to the charge.
para number 8 and 9, your lord.
Yes.
If I may read, your lordship. Para number 8. There is no statutory provision for drawing any presumption that a person who was present at any particular place shall be presumed to be in possession of the narcotics or psychotropic substance. No presumption under law can be drawn even under section 114 of the Evidence Act merely because these persons were present when PW number 7 went there. Either those persons would have been casually present in the room or at least one of them would have been unaware of what was going on inside the room. We are not told who among the many accused the one possible innocent person could have been. In light of the aforesaid improbables, it is difficult to sustain conviction. And one more, your lordship, this honorable court has highlighted several judgments. In one case, which your lordship will kindly see, is 2010 4 GLT 565.
2010
Volume 4,
GLT.
GLT 565.
Yes.
Onyx Maipok versus State of Assam and others. This is a case where the presence of
Paragraph.
paragraph 11, your lordship.
Para 11.
My lord, if I may proceed, paragraph 11.
On a bear. Perusal.
Yes.
No.
No, in the case of
Just a minute. Just a minute.
para 11.
In the case of Murlidhar.
Yes, my lord.
Yes.
Why I'm citing this is the citation made in this in this judgment, your lordship.
Yes.
In the case of Mulidhar Soni, the son was driving a scooter and his father was a pillion rider and carrying few kgs of ganja in a cloth bag. In this situation also, the Honorable Supreme Court has held that the son who was driving the scooter cannot be said to have conscious possession of the ganja and his acquittal was a proof. In the case of Balkar Singh Supra, the accused persons were found sitting on a cluster or bags kept in a field containing large quantity of poppy husks. Despite that, the apex court has approved the acquittal of the accused persons, holding that there was no investigation as to how the strangers, accused persons, had transported 100 bags of poppy husks to the place of recovery, nor the prosecution adduced any evidence about their ownership. The next part is important, madam. In the case of Avtar Singh Supra, the accused were traveling in a truck, and the bag over which they were found sitting was containing narcotic drugs. And in this case also, it has been held that the accused cannot be said to be in conscious possession of the narcotic drug. The lordship have held that possession and ownership need not always go together, but the minimum requisite element which has to be satisfied is custody or control over the goods. So the minimum requisite element is the control over the goods. While acquitting the accused persons, the lordship have further observed that the person who are merely sitting on the bags in absence of proof and nothing more cannot be presumed to be in possession of the goods. In the case of Hari Singh Supra, the Honorable Supreme Court was examining a case wherein 3 men and 2 women were found sitting on the bags containing narcotic drugs. The lordship have held that the word conscious means awareness about a particular fact, and it is a state of mind which is deliberate or intended. The lordship have further observed that to hold a person in conscious possession, it is not necessary to prove that he was found in physical possession of offending articles, but it has to be proof that such person has constructive knowledge of such an article and has the power and control over it. Having said so, the acquittal of the accused persons for possession of 30 kgs of poppy husk was upheld. And in para 12, my lord, the Ismail Khan case was also highlighted. Here, my lord, that is why, my lord, we are submitting that for us to be included as conscious possession, abetment or criminal conspiracy under Section 29 NDPS should be slapped on me. But I was arrested and charged under the harshest punishment under the Act, 22C, carrying 20 years imprisonment, my lord, just because I was there. And the witnesses they have brought to the court for convicting me are biased. They are from the departments of narcotics itself, and only one civilian witness is there, and that civilian witness also says that I do not know Kiran Joy. I did not see Kiran Joy at the place of occurrence. And he also stated that nothing was found from Kiran Joy. So those evidence are the only connecting link to me to the substances, and those links are not connected, Your Lordship. So the evidences are in favor of me, Your Lordship. And on top of that, I've been in custody 782 days, Your Lordship. So the hurdles of 37 has been, we have jumped over the hurdle of 37, Your Lordship. Because they have not says that they are not saying that anywhere in the court that I am in common intention or common mind with other accused. No, they have not said that. So conscious possession is not there, Your Lordship. And the ironic thing is that, my lord, accused number 1, who is the main culprit, and accused number 5 have been released on bail. Now even the IO says that, even the case inspector says that I was merely present there. And he has specifically said that accused number 1 called for the mobile phone, called for the drugs. Accused number 5 was dealing with the decoy customer. The only thing my name came up was I was there in the place. We don't deny that I was not there. So the main culprits are being released. Why me? They've been kept because
what was the consideration for the release? When were they released?
Medical grounds. So, my lord, that is the reason. Because I'm a poor person, I could not afford any lawyer for a long time. I've been prejudiced, Your Lordship. So and no prior case against me. That is why that I don't have any connected persons. I've got no peddler. So it is obvious, Your Lordship, that the twin conditions of Section 37 that I will not do any narcotics drugs is being proved because I have no prior arrest, not even.
No, what about the first presumption? It's a reverse presumption.
Yes, my lord. That I have stated.
The finding, the wordings in the Act, kindly take up 37.
Yes, my lord.
B1, B2.
Yes.
Where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that He is not guilty.
Yes, my lord. There is reasonable ground from the statement of the witnesses himself. From the deposition of witnesses himself, that there's a reasonable ground that I will not involve. Because one, the arresting officer did not say my name. Only said that I was
It's
there.
almost the reverse. Normally, the presumption is of innocence.
Yes, my
Now,
lord.
you have to make out a reasonable ground that you are not guilty.
Yes, my lord. I'll just read PW number 3, who is the civilian witnesses.
Okay, we have read. Any other citation?
Yes, yes, my lord. My lord, the other citation is the one where this After Singh and others versus State of Punjab.
After Singh has been referred in
Yes, yes, my lord.
Guwahati High Court.
Yes, my lord.
What about any latest cases on bail?
It is cases of bail.
NEPS bail?
Yes. My lord, the only submission I have to, but I did not bring is that there's a citation, there's a judgment saying that Section 37 is there, obviously. But we cannot override the fundamental rights. 782 days of incarceration with only one civilian witness who also stated that I did not know Kinon Joy at the PO, and who stated that he was called after the arrest.
Okay.
My lord. So, my lord, I'm a permanent resident of Mizoram. I have a wife, a daughter of 4 years old, your lordship. And I will not abscond, your lordship. So, if your lordship will kindly take into consideration the prejudice I face, and that the evidence as on date is not sufficient to convict me, your lordship, that my lord will kindly grant me respite and bail, my lord.
Yes, madam.
Yes, my lord, what my learned friend have cited, the case of Ismail and After Singh. This based on, if I'm not mistaken, conviction. This is about conviction, and this was already this citation was already used and referred before the learned trial court, and the learned trial court was pleased to dispense with this and reject the order, my lord, or reject the application, my lord.
Okay.
Because it is not a mere fact that he was present at the wrong place, my lord. Because, my lord, if you know the place, it's in Sakor. They have made the arrest at Sakor Tuitsun. Sakor Tuitsun is a little bit outskirt of the Aizawl city. So wherein there is a long gap of houses. So it will just mainly be the road, the stretch of road. And in some picnic spots are there, few of them. So, my lord, it is not in the, they have came to Aizawl to sell a dry fish. So how can my learned friend say that they have overcome the hurdles of the rigors of Section 37 when the trial is ongoing, and that he have choose to accompany his brother-in-law at the outskirt of Aizawl? So at this stage, the King's IO is yet to be examined, my lord. The investigation is yet to be examined. And we cannot say that he do not have a conscious possession or control over it, because it was from the information of the seizing officers, the team, that some persons are in communication to each other, and then accordingly, as per the information they have, they arranged for the decoy at the outskirts of the city. So he chose to follow the co-accused, that is co-accused number 1. So at this stage, the rigors of 37 have to be overcome by the applicant, my lord, at this stage.
What about the long period? 700
The
days?
long period of imprisonment, my
No,
lord.
no, not imprisonment. It's not a question of imprisonment. They are yet to be imprisoned. Long
Yes,
period,
sorry.
Long period being in custody, 782 days.
In custody, yes. My lord, in so far, only three examined at this stage, and another four have to be
One
examined,
is
my lord.
dropped. I think
And they were-
another three, I think, because one is dropped. What learned
Okay.
counsel has informed.
Oh, yes, yes. Number 2 is dropped. My lord, endeavor shall be made to expedite the process, my lord. And direction can be passed, given in this order also, my lord, for that.
Okay, we'll consider. Yes. We'll deliver the order tomorrow.
Well, obliged.
Please write heard so and so. Learned counsel for the applicant. Also heard Ms. so and so. Learned PP or APP. APP.
Lord, additional PP, additional
APP,
PP.
who has appeared online. The submissions have been considered and the order and the matter is reserved for passing orders.
Item number 9.
This is a first appeal by the state. There is a delay of 743 days. And objection is yet to be filed, my lord.
My lord, we just received the signed wakalatnama from the,
Yeah, we filed the wakalatnama.
We'll be filing
Filed.
it.
Okay. Ms. So-and-so, I heard Ms. So-and-so learned state counsel, who has pressed PLE SSED this application for condemnation of delay, in which notice was issued. Para, Ms. So-and-so learned counsel has entered appearance on behalf of the sole opposite party,
my lord, respondents number 1 to 6.
1 to 6.
Yes, my lord.
On behalf of the, not sole opposite, on behalf of the opposite party numbers 1 to 6. And, no, don't say. Ms. So-and-so learned counsel has submitted that she has instructions to appear on behalf of the opposite party numbers 1 to 6 and would be filing the formal power by the, during the course of the day. Full stop. Para, she prays for and is granted 4 weeks time to file objection. Placed after 4 weeks.
If I may seek a lordship's indulgence, my lord. My lord, this is an unlisted item and I'm praying for this matter to be listed tomorrow, my lord, for motion.
Tomorrow it may not be possible. Tomorrow this court has to rise early. What is the matter about?
My lord, this is a writ petition regarding appointment of registrar in the Mizoram University, my lord. So if this matter, I had mentioned it to Justice before
It can
Justice
be placed
Malik,
before that court?
and then she had asked me to come to this court for
Okay,
mentioning.
it will be placed before that court.
Much obliged, much obliged.
We'll allow, provided time permits, it to be placed before the Honorable Justice Mali.
Deeply obliged.
May I
What is the urgency?
My lord, the urgency is,
When
my
did
lord,
you file?
my lord, we have filed it today, my lord.
Today.
Yes. So the only option is, my lord, if it's taken up tomorrow motion.
You could have made a mention early in the morning, would have taken up today itself here by this court.
The only problem, my lord, was because we had filed it after the division bench had sat, my lord. So because of that reason.
You still had time, it was better for you. By the time it was filed, single bench, you would have mentioned. Okay, doesn't matter.
My lord,
Before that.
the same prayer,
Just a minute.
my lord.
Is it? Okay. We'll have a difficulty tomorrow. The other court has some difficulties.
No, actually, my lord, what happened was I had mentioned it before Justice
No,
Murli.
tomorrow it will be, that court will have some difficulty. It has to rise early.
Yes, Lordship, I had mentioned it to her. I'll just explain, my lord. And then, my lord, Justice Murli had told me specifically, my lord, that I should mention it before this court. And if this court says it should be listed, then it will be taken up tomorrow. She specifically said in court, my lord. My lord, that's why I have come here.
We'll try that. If, okay, you try that. If the court has a difficulty, it will be adjourned.
Yes,
Otherwise,
yes,
it will be listed
yes.
for that bench. Okay. Yes, anything?
My lord, this writ petition number 142 of 2024 has been filed on Monday. This,
Why didn't you make a mention in the morning? This is not the mention hour.
my lord, we are of the belief that it will be listed by
You should have made a
tomorrow.
mention in the morning, 10:30 is the mention time, not now. He had an exceptional matter. He was mentioning there. It was not given.